crime in court. My name is Heather, and this is another episode of my Canton cover up Commonwealth versus Karen Reed. And we are going to be talking about, or reading through today, rather, the brief that was just filed to the SJC in preparation for arguments um, that will be heard in front of the SJC. So this is the brief that needed to be filed prior to the hearing, um, I don't know what it's called. I guess a hearing when it's in front of the SJC. I don't know. For whatever it's called when they go and argue for the double jeopardy claims that the defense is making in this case, because obviously we know there was a mistrial, and 6 of the 12 jurors have all stated outside of court now that either through an intermediary or directly to defense or to a reporter that she was acquitted on counts 1 and 3, no doubt about it. So that is what Karen Reed's team is going to be arguing, and this is the evidence and circumstances that basically support their argument. And so let's get started here. Please hit the like button if you don't mind. This is going to be a longer one, but I'm going to try to talk less and read more so that we can get through it, because it is 77 pages. We're not going to read all of that. We'll probably leave out the legal um, stuff at the end because it's confusing sometimes, anyways, and wordy. So let's get started. This is the brief of appellant Karen Reed, filed by Martin G. Weinberg, Michael Pavian, and Alan Jackson, and David Yannetti. Liza Little is not on here, but that is nothing to worry about. She's still on the team. She just isn't part of the appellant process right now. So, okay. So we're going to skip all the way to page 8 because this is all table of contents. All right. So we know a lot of this, but let's read through it anyways, just to be thorough and see if there's any new things. All right, so statement of issues presented: whether the jury's final unanimous agreement following trial that Ms. Reed is not guilty of counts 1 and 3 constitutes an acquittal for double jeopardy, proposes and precludes retrial on those counts. Whether Ms. Reed was alternatively entitled to a post-trial inquiry to substantiate her claim that the jury acquitted her of counts 1 and 3. Whether there was manifest necessity to support the declaration. Did I miss something? What is the? Nope, that's it. It just says all these sentences are starting with whether. So I guess these are issues of whether or not these are accurate, I guess. All right. So whether, I don't know, it's just throwing me the way that all the sentences are starting out with whether, but I guess that's just how they do it. All right. So whether there was manifest necessity to support the declaration of a mistrial on counts 1 and 3, where 1, the jury was not deadlocked and, in fact, had reached a unanimous agreement on those counts. 2, the trial court provided no opportunity for Ms. Reed or her counsel to be heard regarding the declaration of mistrial. And 3, the record reflects no consideration of alternatives to a mistrial when in fact such alternatives existed and were codified in Massachusetts R. Crim P 27B, which means she absolutely should have searched for alternatives that existed besides a mistrial before she declared a mistrial. And she didn't even show the note, first of all, to either side. And she didn't, she basically, she brought in the attorneys, told them the jury has reached an impasse or whatever. And then she doesn't say anything else. She calls the jury in, and she doesn't talk to the attorneys or show them the note, which is when that's supposed to happen, and then discuss the possibility maybe of a mistrial. I'm not sure. But the defense definitely needed to discuss that with Karen Reed. So they didn't have that opportunity. She basically said there's an impasse. She calls in the jury. She reads the note directly and then says, I'm not going to do that to you folks. You're dismissed, mistrial. And then she sends them out of the room immediately and then begins scheduling the next hearing that they're going to have. And I think it just happened so fast that there was no opportunity to say anything. And for Judge Canoni to say that, well, they didn't bring it up, so they waived their right. That is so disingenuous. All right. So, statement of case. On June 9th, 2022, Ms. Reed was charged in 3 separate indictments with a second-degree homicide in violation of GL 265, count 1, manslaughter while operating under the influence of alcohol and leaving the scene of a collision resulting in the loss of life in a violation of um, whatever GLC 90, all those letters and numbers. And there's a footnote which says the page numbers for the record appendix cited in this brief appear in the lower left-hand corner of each appendix page. These page numbers in the center of the page. Okay, they're just telling you how to find what they're referencing. A jury trial began on April 16th, 2024. The trial court declared a mistrial on July 1st, 2024. It's like an 8-9 week trial. It was very awkward because at first it was like not every day. It was like Monday and Wednesdays were full days, but like Tuesdays and Thursdays were half days and then no Fridays or something. I don't know. It was just really weird. And then they take off days all the time. But they finally, like near the end, they had more days where they were going longer days and stuff. Because it was taking so long to get through all of Adam Wally's many, many witnesses. All right, I think there's like 60 or something like that. I don't know. This is a big number. All right, so Ms. Reed moved to dismiss counts 1 and 3 on double jeopardy grounds, contending that 1, the jury failed a final unanimous decision to acquit her on those charges, and 2, that there was no manifest necessity supporting the mistrial, given the evidence that the jury was not deadlocked, but was instead in agreement on those counts. As set forth in more detail, whatever that means, I don't know. The motion was predicated upon affidavits by counsel reflecting statement of 5 deliberating jurors that the jury had agreed Ms. Reed is not guilty. So 5 deliberating jurors had come forward. There was a 6th juror who also said that on a statement of through Turtle Boy's reporting. They came out and discussed or confirmed again they also confirmed they weren't one that had already reached out, so it was a 6th deliberating juror who agreed. After hearing oral argument on August 9th, 2024, on August 23rd, the trial court issued an order denying Ms. Reed's motion to dismiss. The court accepted, for the purposes of the motion to dismiss, that the jurors' statements quoted in the defense affidavit were true and accurate. So she just assumed, okay, let's say they are true and accurate, I still deny it, basically, is what she was saying. But if she's saying that they were true, then they have validity and they should be inquired further. All right, so it went on to hold, however, that because there was no open and public verdict affirmed in open court rendered in this case, the defendant was not acquitted of any of the charges. So because they didn't say it in open court, it wasn't affirmed. That's what she's going with. The court similarly rejected the defense argument regarding lack of manifest necessity, finding that Ms. Reed's counsel consented to a mistrial via their failure to object and B, the jury notes reflecting an impasse established the requisite manifest necessity. Finally, the court rejected the defense's alternative request for a post-trial inquiry on the grounds that Ms. Reed's argument did not implicate racial bias or her right to receive an impartial trial, and because it believed that the request implicated the substance of the jury's deliberations. Ms. Reed's retrial is currently scheduled for January 27th, 2025. On September 11th, 2024, Ms. Reed filed a petition for relief pursuant to GLC 211-3R5 on September 19th, 2024. The single justice, Juror, reserved and reported the case without decision to the full court, meaning the full court will hear arguments on this case. So, here's the statement of facts. On June 25th, 2024, the jury began deliberations after receiving instructions from the trial court. The court instructed the jurors, you should continue deliberating until you have reached a final verdict on each charge. June 25th, 2024. It is also noted that count 2 contained lesser included charges of involuntary manslaughter and motor vehicle homicide, which the jury should consider even if the Commonwealth failed to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. So, how are you going to consider the lesser charges if you think that the main charge of manslaughter, the greater charge of manslaughter, didn't happen, or that they didn't prove that it happened, rather? So that's contradictory and confusing. And I think it's all confusing on purpose, but that's my opinion. I believe Judge Canody is playing on one side, and she is not impartial. All right, the following day, on June 26, 2024, outside the presence of the jury, counsel for Ms. Reed raised an issue regarding the verdict form. With respect to count 2, the original verdict slip provided only one option to find Ms. Reed not guilty before going on to ask whether Ms. Reed was guilty of the offense charged or guilty of one of the lesser 2 included offenses. Counsel asked, so it almost seems like they were leading them to some kind of a manslaughter charge. Counsel asked that the form be amended to provide not guilty options for the subordinate charges under count 2. The trial court initially indicated that indicated its disagreement with counsel's request. She got real snippy and made a fool of herself on TV. However, after considering the matter further, the court agreed to provide supplemental instructions and an amended verdict slip. Later that day, the court provided the supplemental instructions telling jurors that count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a vehicle under the influence of liquor. The jury should first focus on that lead charge, and if the Commonwealth failed to prove that crime beyond a reasonable doubt, then consider the remaining lesser included offenses in descending order. That makes no sense, because if you don't think she committed the first charge, then why would the lesser charges even apply? That makes no sense. All right, so on June 28th, 2024, the jury sent the following note to the court. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. That was June 28th at trial. The court asked counsel for their views on whether there had been due and thorough deliberation sufficient to support the giving of a so-called Tui Rodriguez charge. If a jury, after due and thorough deliberation, returns to court without having agreed on a verdict, this is something that they can do that allows them to do this charge. So the Commonwealth responded that the charge should not be given because there simply hadn't been sufficient time yet. And that was also June 28th. Counsel for Ms. Reed disagreed, requesting that the court read the Tui Rodriguez model instruction and go from there, which the Tui Rodriguez instruction or the Allen charge, whatever you want to call it, it's called different things in different states. So it is not to force a mistrial, by the way, which is what the court is trying to imply, that that's what the defense was trying to do, was to force a mistrial. The Allen charge or Tui Rodriguez charge is actually to try to convince the jury that they can come to some kind of an agreement and that they can overcome some of their disagreements and think of things differently. And it's very pro defense, actually, the way that it was worded. And in this particular case, it's like, weigh on the evidence and all this stuff. So it was very, I thought, pro defense. It would have pushed, if it were to push for a verdict, it would have been, not guilty, in my opinion. But there were still people that did not budge, whether they were plants on the jury or just not looking at all the evidence for some reason. They were really confused by Adam Lawley's many questions about snow, I guess. All right, so the trial court sided with the Commonwealth ruling, I am not prepared to find that there have been due and thorough deliberations at this point, so I am going to send them back out. On July 1st, the jury presented another note stating, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. I think these deeply held convictions, that wording right there needed to be looked into a little bit more, because you shouldn't be going in with bias. And if you're having some deeply held conviction, maybe you're against drunk driving and you believe Karen was drunk driving, so therefore you believe she should be charged with something. That could very have easily happened. So I think that needed to be looked into more, but I digress. All right. Ultimately, leading to the point where consensus is unattainable, we recognize the weight of this admission and the implications it holds. July 1st, 2024. Upon being asked by the court, the parties reiterated their same previously expressed views, with the Commonwealth taking the position that due and thorough deliberations had not yet occurred, and Ms. Reed's counsel arguing that the court should give a Tui Rodriguez instruction. This time, the trial court decided to give the requested instruction. Later that day, the jury sent yet another note thereafter, without regarding the note to counsel and without providing counsel with either an opportunity to be heard or an opportunity to consult with their client about the implication of a potential mistrial on one or more charges. The trial court simply stated, the jury is at an impasse, and called the jurors. It then read the note on record. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements for these charges. The deep division is not due to lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise those deeply held beliefs. Again, with the deeply held beliefs, deeply held convictions, I think she's in the wrong, so she needs to be punished type of mentality, possibly. All right, so after reading the note, and without soliciting the views of counsel in any respect, the trial court stated, I am not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. The jury was then excused and ordered to leave the courtroom. Counsel was not invited to speak during this entire interaction. The following day, and they're not really supposed to speak out of turn, so for her to just say, like, you should have just spoken and said something that was in her argument as to why they waived their right on this. But you're not supposed to, I mean, really, the court is the judge's like the main speaker, and she allows you to speak. She will allow certain people to speak. There's rules and protocols, so you can't, like, attorneys aren't just supposed to speak out. All right, so the following day, on July 2nd, unsolicited by any party, one of the jurors, Juror A, contacted one of the attorneys for Ms. Reed, Alan Jackson. Juror A stated that she wished to inform Attorney Jackson of the true results of the jury's deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty on count 1, second-degree homicide. Juror A was emphatic that count 1, second-degree homicide, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury or loss of life. On 1 day later, on July 3rd, another attorney for Ms. Reed, David Yannetti, was contacted by two different individuals. So again, mistrial happens on July 1st. The first juror comes out to Alan Jackson on the second day, July 2nd. July 3rd, we get another juror, and it just kept like pouring in the affidavits. All right, so 1 day later, on July 3rd, another attorney for Ms. Reed, David Yannetti, was contacted by two different individuals herein after Informant B and Informant C, who had received information from two distinct different jurors, herein Juror B and Juror C, both of whom were part of the deliberating jury in this case. Informant B sent Attorney Yannetti a screenshot that he or she had received from someone hereinafter intermediary B of text messages that intermediary B had received from Juror B. In that screenshot, Juror B texted the following to intermediary B. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose, which is incorrect. It was an error. She didn't mean to type that or text that. Juror B later placed an unsolicited phone call to Attorney Yannetti confirming that the information contained in the publicly filed affidavit was accurate. Juror B clarified, however, that he or she meant to write, no one thought she hit him on purpose or even knew that she had hit him. So if she had done it, then she didn't do it on purpose or even know that it had happened. Like it was an accident and she drove away not knowing that she had hit him. If, the people that thought that it could have happened, that she did hit him, if you believed Trooper Joseph Paul for some reason. All right, so Juror B further told Attorney Yannetti that she believed that every member of the jury, if asked, would confirm that the jury reached not guilty verdicts on indictments 1 and 3. So that is already 4 people? 3 people. All right, informant C had been in contact. This is the third person, sorry. Informant C had been in contact with another individual, intermediary C, who is a coworker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent Attorney Yannetti the below screenshots of his or her text messages with intermediary C regarding what Juror C revealed in the Zoom meeting. Intermediary C says, no consideration for homicide 2. Manslaughter started polling at 6-6, then ended deadlock at 4 no, 8 yes. It was also reported that it was 9-3, and that was confirmed in Turtle Boy's article when he interviewed the juror, and the last two articles that he did are the same juror, and that particular juror isn't one of these, but also they were one that like flip-flopped because one of them talked him into changing his vote, but then he thought about it and changed his mind later. So if you were hearing 9-3, that's why. So intermediary says that. Then informant C says, interesting. If it was no consideration for homicide 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip, and that was all very confusing. Intermediary says, she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. That was a conversation with people that had spoken to Juror C. All right, so in the ensuing days, after the filing of Ms. Reed's initial motion to dismiss, but before the Superior Court hearing on that motion, Attorney Jackson was contacted by two other deliberating jurors. The first, Juror D, stated that the jury reached not guilty verdicts on 1 and 3, and that the disagreement was solely as to count 2 and its lesser offenses. He or she recounted that after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen on count 1 and 3? Juror D unequivocally told counsel, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3, because that's what happened. Juror E similarly stated that the jury was unanimous on 1 and 3, that Karen Reed was not guilty of those charges. That is 5. Commonwealth filed a post-trial notice of disclosure informing the court that on Sunday, July 21st, Assistant District Attorney Adam Lally received an unsolicited voicemail on his office's phone line from an individual who identified theirself as a juror by full name and seat number. The message stated, it is true what has come out recently about the jury being unanimous on charges 1 and 3. So a juror actually reached out to Adam Lally also to confirm the reports about it after the filings came out from Alan Jackson and David Unetti. ADA Lally received a subsequent message from the same individual stating that he could confirm unanimous on charges 1 and 3 as not guilty, and as of last vote, 9-3 guilty on the manslaughter charges. So there's the flip-flop I told you about. So the Commonwealth additionally received emails from 3 individuals who identified themselves as jurors and indicated they wished to speak anonymously. The Commonwealth declined to substantively respond to their voice messages or emails, instead claiming in responsive emails that it was ethically prohibited from discussing such matters, which is a bunch of hooey because they're not asking about what happened in the deliberation room. Why did you come up with your verdict? Why, nobody's asking that. They are simply asking, what was your verdict? What was the outcome of your deliberation? So there's a huge difference as to asking what specifically got you and the whole team to a guilty or a not guilty. It's very different, in my opinion. And because they're not supposed to be asking jurors about the deliberative process. It is in their rules of conduct. But they're not. They're not doing that. But that is one of the arguments that Canoni cited in her response. All right, so summary of argument. The very day after the trial court declared a mistrial, counsel for Ms. Reed began receiving unsolicited communications from 5 of the 12 deliberating jurors, in 4 instances directly from the jurors themselves, indicating unequivocally and unconditionally that the jury had a firm and unwavering 12-0 agreement that Ms. Reed is not guilty of 2 of the 3 charges against her. including the charge of homicide in the second degree. Crucially, neither the Commonwealth, which frankly acknowledged receiving communications from one juror to the same effect, nor the Superior Court judge who expressly accepted the veracity of juror statements relayed in affidavits by counsel, disputed the factual basis for the defense motion in any meaningful respect. So nobody disputes what the jurors are saying. They're just saying because it wasn't on paper and spoken in court, it doesn't count, which is infuriating to me. Whew. All right, so despite the widespread media given to the defense, given to the give sorry despite the widespread media given to the defense filings of the attorney affidavits attesting to the jurors' representation, they had acquitted Ms. Reed of 2 of the 3 charges. No juror disputed the facts represented by the attorneys in any manner. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Ms. Reed on counts 1 and 3 and mandates dismissal of those charges. This presents an issue of first impression for this court, as does the defense's alternative contention that Ms. Reed was entitled to a post-verdict inquiry to substantiate her claim, and that this court's precedents permitting such inquiry regarding claims of external influence and or juror bias should be extended to the present context. Independently, while a jury deadlock constitutes manifest necessity to support a mistrial, there is no authority for the proposition that disagreement as to some counts constitutes manifest necessity for the declaration of a mistrial with respect to all counts. That was a beautifully worded sentence, and I couldn't have done it any better. So, because they couldn't come to an agreement on some of the counts, it doesn't make it manifest necessity, which is the argument, that's the standard, that all of the counts then needed to be mistried or, declare a mistrial on. So, put another way, there was no deadlock as to 2 of the counts on which the trial court declared a mistrial. The trial court's trial court's finding that Ms. Reed, blah, 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 getting tongue-tied here. The trial court's finding that Ms. Reed's counsel consented to the mistrial is contrary to both the factual record and the clear binding case law. The trial court, in its opinion, erroneously failed to apply clear state and federal case law that places the burden of establishing manifest necessity solely and exclusively on the prosecution rather than on the defendant. The trial court also failed to address the 2 guiding principles set forth by the court in the Commonwealth versus Stewart and Commonwealth versus Taylor, that before a mistrial is declared, 1, counsel must have been given full opportunity to be heard, and 2, the trial judge must have given careful consideration to alternatives to a mistrial. The court instead erroneously equated a request for a Tui Rodriguez instruction, which is designed to encourage a verdict, with consent to a mistrial. Exactly. The court, she basically said, well, because you wanted the Tui Rodriguez instruction, that means you wanted a mistrial. You wanted it. And that's not what that means. It is to encourage a verdict, not to get a mistrial in your case. So, in sum, whether the jury acquitted Ms. Reed or alternatively was merely not deadlocked on the relevant counts, the Constitution requires the same result: dismissal. Argument. The ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, which happens still all the time, I might say, including the pursuit of pretended offenses and arbitrary convictions. Also still happening. All right, so prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact that Parliament and the Crown had deprived them in many cases of the benefits of a trial by jury. After securing their independence, the founding generation sought that to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating that constitution. So even if they're acquitted, the state can't appeal that. There's no appeal process for that. Like you have to uphold an acquittal. Like O.J. Simpson. We could never go after him again because the acquittal is one of the most sacred things in our judicial system. So the Double Jeopardy Clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life and limb. The underlying idea, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the system with all its resources and powers should not be allowed to make repeated attempts to convict an individual for an alleged offense. Even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. At the heart of this policy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. This court reviews determinations regarding double jeopardy de novo. I don't know what that means. Let's look that up, shall we? Hold on one second. All right. So, what did I say? No, de novo is a Latin phrase that means anew, from the beginning, or afresh. It has multiple meanings, including applied in law. When a court hears a case de novo, it means that the court is deciding the case without referring to any previous court's decision or assumptions. There's no precedence for this because this has never happened, likely, in all of whatever history of our judicial system. Or if it has, it was probably remedied instead of the judge being so defiant. So this can include a complete retrial or a thorough review based on new evidence. De novo review is common when reviewing legal matters on appeal, but trial de novo is less common because it requires more time and judicial resources. So not necessarily a trial, but for a review of, say, a panel of the superior court, superior justices. So, or supreme justices, right? I don't know, whatever. So, you know what I mean. So what constitutes, oh, sorry, one, these are the arguments again. So number one, the jury's unanimous conclusion following trial that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. What constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents a solution, correct or not, of some or all of the factual elements of the offense charged. So, there could have been a resolution, but instead she chose the hard way because she's doubling down and saying, nope, I want Karen Reed to be retried on everything. So the mere presence or absence of check marks on a form is not dispositive. So it doesn't prove that you can't prove a negative. I'm sorry, I keep looking at my notifications because Aiden Turtleboy Carney is supposed to be he posted on Twitter or X that he was going to be posting something, he was going to be posting like a big story. So I'm kind of waiting because if I do hear from him first, I might just break it here unless it's something here's falling out. Unless it's something that I want to put in a separate video. I think I'll announce it here if it comes in, the whatever this big story is that he's working on. All right, so there was nothing. Oh wait, no, back up. Here, the affidavits by Attorney Jackson and Unity reflect statements by 5 deliberating jurors that the jury had reached a final unanimous conclusion that Ms. Reed is not guilty of counts 1 and 3. There was nothing tentative about the jurors' statements. It wasn't like, well, maybe we did. No, they were certain. To the contrary, they were definitive in describing the result of the jury deliberations. Juror A was emphatic that count 1 was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime. Reflecting text message from Juror B, it was not guilty on second degree. No one thought she hit him on purpose or even knew that she had hit him. Then we have Juror C's statement relayed by intermediary C that there was no consideration for homicide 2 and Ms. Reed should have been acquitted. Juror D, without hesitation, said in substance, every one of us will agree and acknowledge that we found Karen Reed not guilty on counts 1 and 3 because that's what happened. The juror that Turtleboy had interviewed said that they had taken polls, periodically throughout their time deliberating, and it was always 12-0 not guilty for counts 1 and 3, and eventually they just stopped asking on those, and then they kept doing like a count for just charge 2. So it was like done deal, put away. They had already decided it. It just wasn't written down because she said not to do so. Judge Canoni. As noted above, the trial court accepted the foregoing averments as true facts. In rejecting Ms. Reed's claim of acquittal, the court relied solely upon the lack of an open and public verdict affirmed in court. This reasoning is rooted in formalism that has been consistently rejected by the United Supreme Court and this court in a string of precedents spanning more than 100 years. Where did I miss the footnote? Oh, it was in the paragraph before. So, just days ago, an article was published online reflecting an interview with an anonymous juror quoted as saying it was very clear on charges 1 and 3. Homicide was decided on day 1. She did not have an intent to take his life. And that was, according to the Aiden Carney turtleboydailynews.com is his website with where he posts all of his articles. All right, so where were we? However, it may be in England, in this country, a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense, holding that judicial grant of, according to Hudson and versus Louisiana, holding that judicial grant of new trial prohibited retrial on double jeopardy grounds, notwithstanding that the state code of criminal procedure did not authorize trial judges to enter judgments of acquittal in jury trials. All right, that was all a mouthful. Indeed, under the trial court's reasoning, affidavits executed by all 12 jurors attesting to a final unanimous decision to acquit would not be sufficient to mount a successful double jeopardy challenge. So, according to Judge Canoni, even if all 12 of them said it was fine, that they were final on that, it wouldn't count. It doesn't count as double jeopardy. We can still charge you anyways. Surely that cannot be the law. Indeed, it must not be the law. And in the context of this highly publicized case, it strains credulity to suggest that if the unequivocal statements of 5 jurors quoted above did not, in fact, represent the unanimous view of all 12, the remaining jurors would allow the inaccuracy to go uncorrected. Yeah, why haven't the other 6 come out and said, hey, that's not right? They haven't said anything. Instead, they would predictably have notified the Commonwealth or the court of their own recollection. Here, to the contrary, the Commonwealth has received the exact same information as the defense regarding the jury's unanimous agreement to acquit Ms. Reed on counts 1 and 3. The United States Supreme Court's decision in Bluford is not to the contrary, as it is factually distinguishable from the instant case. There, this is the case that the Commonwealth is citing as to why she should be retried again, this Bluford case. So there, the foreperson had reported during deliberations that the jury was unanimous against the charges of capital homicide and first-degree homicide, but split on manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the Double Jeopardy Clause prohibited reprosecution for capital and first-degree homicide. In doing so, the court relied heavily upon the lack of finality of the jurors' report. The jury's deliberations had not yet concluded, and it went back to the jury room to deliberate further. The foreperson's report was not a final resolution of anything, and there was no indication at the conclusion of deliberations that it was still the case that all 12 jurors believed the defendant was not guilty, if that makes sense. So they were still in the process of deliberating. It had not been made final. In this case, it's different because they all basically said it's final, and that's that. All right, so the contrast with a juvenile versus Commonwealth is even clearer. In this case, after the conclusion of trial, a court officer found 4 verdict slips in the deliberation, 2 of which reflected entries of not guilty. So this is an instance of a court officer found a verdict slip that had a not guilty checked. There was no indication and this was in the deliberation room, sorry. Somebody just found this in the deliberation room after the jury left. So there was no indication as to when the entries were made or in what circumstances, much less that they reflected a final unanimous conclusion of all jurors. Neither the Commonwealth nor the trial court has cited any case in which a defendant was forced to stand trial a second time for an offense a previous jury had found her not guilty, or simply because such final unanimous agreement was not announced in open court. Another case, arguing that Commonwealth had not cited a single case with facts like this that have been ignored. Not a single precedent have they raised nationwide, state courts, homicide cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, but she was acquitted. Other cases cited by the trial court on this issue did not involve double jeopardy challenges. So whatever cases Canoni was citing did not involve any anyone being tried a second time for charges that they were acquitted on. Instead, these cases both vacated convictions where courts responded to ambiguous communications by jurors in such a way as to improperly influence the return of guilty verdicts. Given the gravity of criminal conviction, it makes sense to insist on observance of procedural formalities before taking away a defendant's liberty. However, in light of the fundamental constitutional prohibition on double jeopardy, refusing to give effect to a verdict of acquittal due to its lack of formality is another matter altogether for which neither the Commonwealth nor the trial court has cited any precedent. Bam. Additionally, unlike the Zacharias and Floyd P., there is nothing ambiguous or tentative about the post-trial evidence of verdicts. Yeah, they're not tentative, definitely. The instant case squarely presents that issue, and the defense respectfully submits that this court should hold that any lack of formality does not supersede the defendant's fundamental constitutional protections. So just because you didn't formalize it on a piece of paper and on record in the court of law doesn't mean it didn't happen, and it doesn't mean that she should be tried again because Judge Canoni failed to do what was proper. This issue is one of existential importance, not merely to Ms. Reed, but to the very foundation of the constitutional safeguards that protect her. This is key because what if some other innocent person gets railroaded and they get forced into this kind of a situation and where the courts seem to have it out against that person and they get put in this situation and then have to get retried again and they get found guilty. So this is it doesn't just affect Ms. Reed, it affects our constitutional rights, your constitutional rights, mine, everybody's who lives in America. This is important stuff and that's why the Supreme Court should take a look at it. All right, number 2, alternatively, the defense is entitled to a post-verdict judicial inquiry to determine whether the evidence supports the juror representations as to having acquitted Ms. Reed. The trial court was wrong to artificially limit the right to a post-trial inquiry to develop a substantial claim of a constitutional violation to the narrow extent of claims implicating racial bias or the right to receive an impartial trial. This court has not framed the availability of post-trial inquiry so narrowly, instead stating we will permit juror testimony regarding overt factors by which the verdict's validity can be objectively assessed, such as extraneous influences on the jury, but not regarding the substantive mental processes of jurors, such as the reasons for their decisions. So again, you can't ask them why you came up with a deliberation or why you came up with a verdict, but you can ask about you can ask what is your verdict. That's not against the rules. All right, so in another case, Fiddler, this court rejected the Commonwealth's suggestion of an inflexible rule excluding all juror testimony offered to impeach verdicts as achieving stability at the expense of doing justice between the parties. Instead, the court ruled where the defendant's claim is predicated upon the presence of overt factors, the law's commitment to a just result warrants receiving evidence. But where the juror would testify solely to matters resting in his own consciousness, the dubious value of the testimony is outweighed by the need for stability in verdicts. Fiedler expressly recognized that the line between overt factors and matters resting in a juror's consciousness is not easily drawn, and difficult cases will arise. But it went on to observe, we think it possible to draw the line in most cases, and in any event, the better course is to try to do so rather than refuse to try. The law is clear that in the context of juror bias, an affidavit by counsel is sufficient to entitle the defendant to a post verdict inquiry on the issue. So, why didn't she offer? Or, allow them to at least bring in the jurors. Do it privately. We don't care. Bring them in. Ask them, was this your verdict? Did everyone vote this way? Was there any outside influence? Because now I think that there might have been due to the interviews with Turtle Boy. But, anyways. All right. So, if the credibility of the affidavit is an issue, the trial judge should conduct a hearing to determine the truth of falsity of the affidavit's allegations. So, if the prosecution is saying, "Hey, those affidavits are incorrect or not accurate," then you need to provide, you can come out and prove it. The judge should conduct the hearing. That's the point. So, if the prosecution is saying that wasn't their verdict, then but the defense is saying that was, then you need to call them in and just ask them. That's like the easiest, simplest solution. And that's the only way you're going to get the answer. In so holding, this court stated where a defendant submits a motion raising the possibility that she did not receive a trial by an impartial jury, which was her fundamental right, it cannot be ignored. No less than the right to be, or no less than a right, no less than the right to an unbiased jury, it is a fundamental tenet of our system of justice that a defendant may not be retried for a crime of which she was previously acquitted by a jury, and the defense submits the post-verdict inquiry is equally warranted in the present context. Other than generally noting that the present case does not involve an allegation of juror bias, the trial court did nothing to distinguish the legal basis and justifications in McCallop from those raised herein by the defendant. The defense respectfully submits that the court should hold that the presence of an unannounced verdict, supported by the unambiguous post-trial statements of 5 deliberating jurors. During an inquiry into the validity of a verdict, the court may ask the jurors individually to affirm publicly that the verdict as recorded represents their decision. So the court may ask the jurors individually to affirm their verdicts. So that is case law right there. And that is what the defense is asking for, not to impede on their, sacred deliberations. That's not what they're asking. So, permitting juror testimony that a mistake was made in entering the verdict on the verdict form. Given the foundational importance of jury acquittals in our system, in our justice system, this is a circumstance in which the law's commitment to a just result warrants receiving evidence. Recently, in United States versus Tsarnaev, is the Boston Marathon bomber, one of them. The First Circuit Court of Appeals remanded the matter for further proceedings in the Boston Marathon bombing case due to 2 jurors posting on social media recording the bombings and the district court proceedings, which came to light after the jurors had been provisionally selected to serve. The comments did not reflect racial bias in any way, but rather possible bias specific to the defendant. So it doesn't have to be racial bias, it just has to be bias, which that was one of Canoni's arguments that, well, it's not racial bias, so this doesn't count. So annoying. All right. So the comments were also inconsistent with the jurors' assurances that they had not discussed the online case. The First Circuit held that the district court erred by failing to inquire about these issues with the jurors, given that the right to an impartial jury is a constitutional bedrock. When there is a plausible claim that a prospective juror lied in a manner that may reveal bias, a court need conduct some inquiry reasonably calculated to determine whether the prospective juror did lie, and if so, why. Crucially, for present purposes, the First Circuit ordered the district court to voir dire the jurors. In doing so, the court acknowledged no doubt any juror would have strong incentives to avoid admitting having committed perjury during voir dire. We also expect that most jurors, having taken time out of their daily lives to receive evidence at trial, deliberate with other jurors, and reach a verdict that they believe is just, would prefer not to have the verdict disturbed, especially as a result of their own actions. So, because they didn't write it on the form, I'm sure they don't want to be responsible for her not getting the acquittal. We have no doubt that the able district court judge can do what judges regularly do, form a considered opinion about the sufficiency of the jurors' explanations once those explanations are given and explored. Likewise, the experienced trial court in this matter, aka that means you, Canoni, sub judice. Oh, geez, we need another lookup. Hold on one second. All right, so sub judice means under judicial consideration and therefore prohibited from public discussion elsewhere. The cases were still sub judice, is an example. All right, so in this case, all right, so we have no doubt that the able district court judge can do what judges regularly do, form a considered opinion about the sufficiency of the jurors' explanations once those explanations are given and explored. Likewise, the experienced trial court in this matter sub judice can, after conducting an appropriate judicial inquiry, make findings as to whether in fact Ms. Reed was acquitted. All right, so they're saying Canoni in this matter can, after conducting an appropriate judicial inquiry, make the right findings, I guess, as to whether or not she was acquitted. In another high-profile case, I don't know why they would trust her because I don't. In another high-profile case, the South Carolina Supreme Court recently agreed to hear claims by Alec Murdaugh and that's how you say his name, it's weird, Alec Murdaugh, that during this homicide trial, the clerk of court improperly influenced deliberating jurors. Jurors came forward after the clerk published a book about the trial describing her efforts to obtain a guilty verdict through improper jury tampering. The clerk allegedly told jurors after the defense began its case not to let the defense throw you all off or distract you or mislead you, and warned them not to be fooled by Mr. Murdaugh's testimony in his own defense. The trial court held an evidentiary hearing on the motion for a new trial, including testimony by jurors. As in Tsarnaev, the issue was not racial bias, but nonetheless implicated fundamental constitutional rights, like Miss Reed's right not to be retried for offenses of which she has already been acquitted. The trial judge dismissed Miss Reed's reliance upon Tsarnaev and Murdaugh in a brief footnote, simply stating that the circumstances are readily distinguishable from those at issue here. But that misses the forest for the trees. While it is certainly true that all these cases raise different issues, the fundamental point remains the same. The defendant who comes forward with credible evidence of a serious constitutional violation post-trial must be entitled to an opportunity to prove those claims. There is no apparent reason to artificially limit the availability of such constitutional inquiry to the single context of racial bias, as the trial court suggested. Here is a footnote, and it's quite long here. All right, so the court has permitted post-verdict inquiry of jurors consistent with the Tsarnaev and Murdaugh examples. What is that from? some other case. A juror posted a message on an internet mail service stating that she was struck in a 7-day long jury duty R word slash SA case. Just say he's guilty and let's get on with our lives. And it was clear to what extent juror received responses. So there was some text message. Wow, that's bad. All right. Attorney affidavit reflecting juror statement that a female juror's husband had conversations with some of the witnesses in this case during the course of the trial, and these conversations were made known to said juror, the female juror. Another juror affidavit says alleged that one juror stated the defendant had been shot at it, shot at in Charlestown a month earlier. Sorry. Wow, words are not working. I'm getting tired. This is what happens when these documents are so long. All right. Sorry. So after the jury had returned its verdict, the petitioner learned for the first time that during the trial, a person unnamed had communicated with a certain juror who afterwards became the jury foreman and remarked to him that he could profit by bringing in a verdict favorable to the petitioner. And as a result, the FBI was requested to make an investigation and report. So jury tampering is a thing. And if there was any, it should be investigated here. All right, so the defense request does not in any manner infringe upon the substance of the jury deliberations. To the contrary, the motion to dismiss was predicated solely upon the result of such deliberations, namely a unanimous decision that Ms. Reed is not guilty of homicide in the second degree. The relevant inquiry could be accomplished by a single yes or no posed to the single yes or no question opposed to the jurors. Did you unanimously acquit Karen Reed of the charges in counts 1 and 3? Of course, the results of the jury's deliberations are not secret. They are, in fact, routinely announced in open court. Here, the defense has learned post trial that the jury reached a verdict that was not so announced. It was at least entitled to the opportunity to substantiate that fact in order to ensure Ms. Reed is not unconstitutionally forced to stand trial for criminal offenses of which she has already been acquitted. Such inquiry in no way intrudes on the deliberative process of the jury. Such an inquiry instead honors the jury service, which the trial court prescribed was extraordinary rather than disregarding the efforts of 5 jurors to disclose that there was not an impasse on all 3 of the contrasted as to only one. Indeed, it was the trial court, not the defense, that injected issues regarding jury deliberations into the inquiry. It is simply not true that given the content of the jury's final note to the court, an inquiry would necessarily require the court to understand why the jury's final note communicated a deadlock on charges when post-trial certain deliberating jurors are purportedly stating that the jury was in fact unanimous on most of the charges. As explained infra pages 45 to 46, in light of the trial court's instructions repeatedly characterizing the lesser included offenses within counts 2 as discrete charges, the jury's note is readily susceptible to interpretation consistent with the post-trial evidence supporting the defense's motion. So this distinguishes the case from a juvenile, where the jury foreman had expressly indicated that the jurors were deadlocked on the complaint which charged homicide, and the jurors subsequently reaffirmed the fact in open court. In these circumstances, a post-trial subpoena to the foreman regarding verdict slips, well, this is another long one, regarding verdict slips recovered from the deliberation room after trial regarding the very count could only be aimed at impermissible impeachment months after the fact of the jury's report to the judge in open court. Here, by contrast, no statement of inquiry was made regarding whether the impasse related to a specific count. Jury note expressly stated that the jury could not reach a unanimous verdict as to either of the two indictments. Moreover, as discussed supra page 25, I don't know what those mean, infra and supra. Let's find out. All right, so what were the words again? Supra means earlier, something that was referred to earlier, and then um, infra means below, see below, I guess. So they're just Latin. All right, where are we now? That confused me or got me all off track. Supra. I don't know where I was. Moreover, as discussed above, pages 25, the unsubmitted verdict forms recovered in a juvenile were far less clear than the post-trial evidence at issue here in establishing a final unanimous acquittal. Accordingly, the instant case involves strong, overt factors warranting inquiry. So basically, Judge Canoni should basically have no choice but to bring them in and ask them questions. It's the only way you're going to find out what the solution is here. All right, we're on to number 3, the third argument as to why she should receive an inquiry to the jurors. So, re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was not deadlocked. Absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose initial trial ends without a conviction. This rule is rooted in the importance to the defendant of being able, once and for all, to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. We missed the other. Oh, I skipped a bunch because of the weird footnotes. Man, oh man. Where'd footnote 5 go? Lost it. Oh, here. In any event, if the jurors state that they acquitted Ms. Reed, no further inquiry regarding the contents of the jury note could possibly remove the clear constitutional implications of such acquittal. So basically, if they all say that they acquitted her, then there's really nothing that the prosecution can do. Then it's on record and it's clear. And the only way to find out is to bring them in. So, absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose initial trial ends without a conviction. This rule is rooted in the importance to the defendant of being able, once and for all, to conclude her confrontation with society through the verdict of a tribunal that she or he might find favorable disposed to her fate. The Double Jeopardy Clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. Importantly, the heavy burden of establishing manifest necessity to justify a mistrial is excessively on the Commonwealth. So the heavy burden is on them. And this burden remains solely upon the Commonwealth, regardless of whether or not the defendant objects to the declaration of a mistrial. So the whole manifest necessity, was it necessary? That relies solely on the Commonwealth. That's the burden of the of the Commonwealth, the state. So, why are they like making the defense prove the manifest necessity? And this burden remains solely upon the Commonwealth, regardless of whether or not The defendant objects to the declaration of a mistrial. Before a court declares a mistrial for manifest necessity, counsel must have been given full opportunity to be heard, and the trial judge must have given careful consideration to alternatives. Here, the defense respectfully submits that the lack of opportunity to be heard alone is dispositive. So, um, it doesn't prove the fact that they weren't able to speak doesn't prove that they were willing or enabling it in any way. Upon receiving the final jury note, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Let's not read through all those. So the defense was provided no opportunity to object to the declaration of a mistrial or to advise the court of the imperatives of Mass R. Crim P. 27b, request that the jury be polled or discuss the issue with Ms. Reed. So there was no opportunity for any of that. Defense respectfully submits that given the importance of double jeopardy protections and the profound implications of a retrial, for a criminal defendant, an opportunity to be heard must, in order to be meaningful, occur after a reasonable opportunity for counsel to consult with their client. Counsel for Ms. Reed clearly had no such opportunity here. Whether or not the trial court was obligated to obtain Ms. Reed's personal consent, its failure to at least ensure that counsel had an opportunity to consult with Ms. Reed on the issue undermines the existence of the manifest necessity. The record is independently lacking on the second prong, as it reflects no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked. This option is apparent from the face of Mass R. Crim P. 27b, which states that the judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdict slips on those charges upon which the jury can agree, and direct that such verdicts be received and recorded. That's what she failed to do. In fact, the reporter's notes expressly indicate that such reception of partial verdicts is required before a mistrial may be declared for manifest necessity. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. Had the court inquired as to the existence of any partial verdicts and the jury articulated its verdict consistent with the statements of jurors A through E, the double jeopardy implications would have been clear and decisive. Indeed, with virtual anonymity, the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. According to United States versus Mascolade, I don't know how you say that. Also, Wallace versus Habner. When the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached agreement. So that is what should have happened. But she wants to talk about form. Form was not followed in her courtroom. So she wants to have it be formalized. Well, her formal process of coming to a verdict was improper. In denying the motion to dismiss, the trial court erred by relying primarily upon the lack of objection by defense counsel. In doing so, it utterly neglected to acknowledge the clear and long-standing case law, placing the burden of establishing manifest necessity squarely on the prosecution. Nickel provides a helpful analog. The defendant in Nickel was charged with operating a vehicle under the influence of alcohol. Only 6 jurors were impaneled, and after trial began, one juror recognized a witness and informed the trial judge that he might not be able to be impartial. The judge excused the juror. Left with 5 jurors, the judge and attorneys briefly discussed how to proceed. Defense counsel expressed his frustration over the impanelment of only 6 jurors and then stated, "I don't think we can go forward with 5 jurors, can we?" The judge responded, "Not in a criminal case. Okay, I'm going to declare a mistrial." After a retrial was scheduled, the defendant moved to dismiss the double jeopardy grounds. On double jeopardy grounds. The trial judge allowed the motion, finding that contrary to his initial understanding, Massachusetts procedural rules would have allowed the trial to continue with 5 jurors, albeit with the defendant's consent. The judge therefore found that he had failed to give careful consideration to the alternative of proceeding with the trial before less than a full jury. And accordingly, there had been no manifest necessity for the trial because there was no reason to say mistrial because you could have continued potentially if the defendant was okay with that. On appeal, this court began from the premise that due to the importance of the double jeopardy protection, the Commonwealth bears the heavy burden of proving that a mistrial rested on manifest necessity. The court then agreed with the trial judge that the defendant could waive his right to a trial by a jury of at least 6. It rejected the Commonwealth's argument that the defendant in the case at hand had not provided such a waiver, observing the question is not whether the defendant executed a valid waiver, but whether there was a manifest necessity for declaring a mistrial. Such necessity would have presented itself if defendant had declined to execute a waiver, but the record is clear that neither the judge nor counsel was aware or even considered the option. In these circumstances, the Commonwealth was unable to satisfy its heavy burden of proving that there was a manifest necessity for declaring a mistrial. The defense respectfully submits that the same result is required here. It is the prosecution's burden alone to ensure that the declaration of a mistrial is supported by manifest necessity, even where, unlike in the present case, defense counsel was expressly offered the opportunity to be heard on how to proceed and explicitly shared the judge's mistaken view that the trial could not continue with fewer than 6 jurors. This court held that the alternative to declaring a mistrial was not adequately considered. Here there is no doubt that the court was permitted to accept a partial verdict, but the record simply reflects no consideration of that option. Accordingly, as in Nickel, the charges in this matter must be dismissed. Neither Ms. Reed nor her counsel consented to the declaration of a mistrial. Consent may be implied where the defendant had the opportunity to object but failed to do so. Pellegrin versus the Commonwealth. But the law is clear that such consent may not be inferred from counsel's silence alone. So just because they were quiet didn't mean that they were accepting of what was happening. Rejecting argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. Commonwealth versus Betsaya. Holding that where the trial judge did not ask defense counsel to comment on the possible declaration of a mistrial, the lack of an objection from defense counsel cannot be construed as consent to such action. Here, no such consent was sought, nor was it given. The trial court's ruling that Ms. Reed's counsel impliedly consented to the mistrial was based primarily upon counsel's request for Tui Rodriguez instruction. Of course, whether the jury had engaged in due and thorough deliberation to support the Tui Rodriguez instruction and whether there is manifest necessity to declare a mistrial are distinct legal questions. In fact, the Tui Rodriguez charge is designed to urge the jury to reach a verdict, not to avoid one. And that is from Commonwealth versus Sameto. Unsurprisingly, neither the Commonwealth nor the trial court cited any case finding a defendant's consent to a mistrial can be based on a prior request for a TUI charge, the TUI Rodriguez charge. Here, defense counsel's requests, sorry, I missed a footnote. In Ray, at 2 to 3, after the jury reported a deadlock, the judge indicated that he was inclined to declare a mistrial. The parties responded by requesting that the judge give the jury a Tui Rodriguez instruction as an alternative to a mistrial, so that could be an alternative. Here, defense counsel's request did not reflect any implicit concession that the jury was deadlocked on all counts, nor did they commit the defense to any position regarding whether the court should sua sponte, all on her own, declare a mistrial, which is exactly what she did. She didn't ask, she didn't consult, she didn't look at any other options. It was just mistrial, bye. Get out of my courtroom. It is true that if the jury reports an impasse after a Tui Rodriguez instruction, they shall not be sent out again without their own consent. The fact, however, does nothing to undermine the alternative of simply inquiring pursuant to Mass R. Crim P. whether the jury had reached any partial verdict. Doing so would not require the jury to be sent out again. The trial court was in error in equating a request for a Tui Rodriguez charge with any acceptance of or acquiescence to a mistrial. So she was conflating the two. They are not the same, and they explained why. Moreover, the trial court's characterization of the jury's final note as making it clear that the jurors would not consent to continuing their deliberations is belied by case law cited in the court's order. In Commonwealth v. Jenkins, the jury simply reported after a TUI charge that they felt strongly that there was no hope of progress and requested further instructions. Didn't mean they were trying to get a mistrial. The court responded by telling the jury, I cannot force you to continue deliberations unless you agree to continue, and then asking them to retire and decide whether further deliberations on the next day would be fruitful. So that was this other case, and that's very much like what Judge Canoni did, because she sent him back and sent him back again. It was a lot of back and forth. The jury promptly reached a verdict after that. The court held that the object of the statutory prohibition on sending the jury back out without consent was fulfilled because the jury consented to continue their work. The jury's return of a verdict after sending their last note implicitly satisfied the statutory requirement of jury consent. Thus, another alternative to a mistrial, which the trial court did not consider in this case, would have been to inform the jury that it could not be required to continue deliberations without its consent. So Canoni didn't even tell them that. She could have said that she couldn't force them, and then she could have asked them to retire to consider whether it was prepared to return any partial verdict. So that was what she probably should have done, but she did not, as we know, which is why we're here. So here, neither Ms. Reed nor her counsel were provided an opportunity to object to the declaration of a mistrial as opposed to the appropriateness of a Tui Rodriguez instruction. All of the cases cited by the trial court on this issue are readily distinguishable on that basis. For example, in Pellegrin, a witness testified at trial to incriminating evidence that had not been disclosed to the defense. This court held that the defense had an opportunity to object given that the mistrial was declared after a voir dire of the witness and colloquy after the jury was cleared from the courtroom. Here, by contrast, the defense did not learn of the contents of the jury note or the court's intention to declare a mistrial until the judge called the jury in and stated the declaration of a mistrial on the record. Counsel was never shown the note from the jury, and that's important because they should have been shown it before it was ever read out loud in court. The judge indisputably never informed counsel of its intents to declare a mistrial, much less solicited counsel's views on the matter. Compare United States versus McIntosh, ruling in case where defense counsel at one point implored the district court to declare a mistrial because the jury was deadlocked. It would be Kokofsky-esque and wrong to allow parties freely to advocate on appeal positions diametrically opposite to the positions taken by those parties in the trial court. United States versus U. After co-defendant moved for mistrial, the court subsequently stated that it was going to declare one and asked the attorneys if either wished to make any record. So these are examples of, hey, you did it wrong, Judge Canoni. Defendants had moved for a mistrial a scant 2 hours before one was declared at the first suggestion of jury deadlock. All right, so as the appeals court has explained in an analogous factual context, the suggestion that counsel could or should have immediately objected to the sua sponte declaration of a mistrial underestimates or ignores the difficulty of reaching a decision in which the defendant has an evident personal stake, whether the defense would be advantaged or the opposite by a second trial. Possibilities ahead, such as the appearance of a new prosecution witness, cannot be instantly calculated. Therefore, to equate silence with consent when the occasion comes abruptly and unexpectedly seems quite unwise. And that is a quote from another case, which is just a beautiful quote, which fits this case perfectly. So I'm going to read it again. Therefore, to equate silence with consent when the occasion comes abruptly and unexpectedly seems quite unwise. Judge Canoni, this means you. The trial court's suggestion that defense counsel had an opportunity to object to the declaration of a mistrial after it had occurred and the jury had been discharged is mistaken. The judge expressly told jurors, "Your service is complete. I am declaring a mistrial." Given counsel's lack of an opportunity to be heard and the court's lack of consideration of alternatives, the defense respectfully submits that the prosecution has not satisfied its high burden of establishing manifest necessity for the mistrial. While the trial court correctly observed that jury deadlock may be grounds for a mistrial, it cited no precedent for the counterintuitive proposition that a deadlock with respect to some, but not all counts constitutes manifest necessity for the declaration of a mistrial as to all. Does that make sense? So there's no precedent saying that you should declare a mistrial as to all of the counts when there was only a deadlock on some of the counts. Compare Fuentes versus Commonwealth, affirming declaration of mistrial where note expressly stated that the jury could not reach a unanimous verdict as to either of the two indictments. So that's different because they were clear. In the notes that Karen Reed's jury sent back, they did not specify. They just said generally the charges, which there were multiple charges with one with multiple counts. So, or with lessers included. So you can't you can't say that when they say we can't come to a conclusion on the charges that they mean all of the charges. They might have meant a portion of the charges. So like the defense said, there's two meanings to the way that the note could be read. And the court's taking it as, well, they couldn't decide on anything. And the defense is taking it as, well, they could maybe have a partial verdict, because truly they could, based on the wording. They didn't eliminate that possibility. So this lack of precedential support is no accident. Such a rule would run counter to the important interests underlying the constitutional safeguards against double jeopardy. So they're saying the reason why there's no precedent for this is because it's never happened before, because it is exactly the opposite of what our justice system is supposed to do and what our constitutional safeguards in our legal system are supposed to protect us against being charged a second time. Contrary to the trial court's suggestion, there was nothing in the jury notes that directly contradicted the post-trial affidavits by counsel. As an initial matter, there is a facial tension between this observation by the court and its stated acceptance of the affidavits as true for purposes of the motion to dismiss. So even the Judge Canoni said, "I believe these statements. So why are we here?" And the jury's reference, so obviously she doesn't believe, and the jury's references to charges is easily reconciled with the post-trial affidavits affirming that the only deadlock related to the lesser included offenses on count 2. Indeed, the court repeatedly referred to those lesser included offenses as distinct charges, both in its initial substantial instructions. Oh, sorry, in its initial and supplemental instructions to the jury. So she told them twice to look at them as separate and distinct charges, the lessers of count 2, which is a no-no. In this context, the jury's note was facially susceptible to two alternative interpretations. One, that the jury had reached an impasse as to all charges, or two, that the deadlock applied to only some of those charges. For example, the lesser charges included allegations within a single count, such as count 2. The information received from jurors post-trial proves the latter interpretation was correct. The jury's failure to expressly mention its agreement on counts 1 and 2 is understandable in light of the court's instruction that it should continue deliberating until it had reached a final verdict on each charge. This court's holding in Commonwealth versus Ross that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. Roth was rooted in the belief that inquiry concerning partial verdicts on lesser included offenses that have not been separately charged arises a significant potential for coercion. Ooh, a significant potential for coercion. So they're trying to coerce an answer out of the jurors potentially. According to Bluford, declining to require court to consider giving the jury new options for a verdict in the form of partial verdicts on lesser included offenses, where under Arkansas law the jury's options were limited on two, either convict on one of the offenses or acquit on all. Such inquiry, in effect, implies that the jury should consider conviction on the lesser counts. No similar danger is present, whereas here the jury was asked to return three separate verdicts on three separate counts. Blah, blah, blah. All right, so see Roth, distinguishing situation where a defendant has been charged in separate indictments or complaints, each with a separate verdict slip, where complaint or indictment on multiple charges, multiple counts, charges, multiple crimes, a general verdict could be returned as to one of the counts despite deadlock on the other counts. In this circumstance, where the jury reports a deadlock without specifying the counts on which it has reached an impasse, it is straightforward and the defense contends constitutionally required follow-up to ask whether the deadlock relates to some as opposed to all counts. Contrary to the trial court's suggestion, an inquiry regarding whether the jury had reached a partial verdict on any of the three separately charged counts would not necessitate any forbidden inquiry on the lesser included offenses contained within count 2. There is simply nothing coercive about asking a jury reporting a deadlock that fails to specify which counts they are deadlocked on relates to a single question of whether its deadlock is on certain but not all counts and if it has reached a unanimous verdict on any counts. Commonwealth versus Foster, affirming trial judges' taking of partial verdicts on 2 of 4 separate indictments and observing to include the jury could have felt pressure to convert provisional verdicts against the defendant into final ones and to abandon all doubts that they may have privately entertained runs counter to the clear instructions of the judge and amounts to mere speculation without any support in the record. Continuing with Roth and Roth versus Massachusetts, right? Noting in the context of deadlock jury, the Rule 720 or Rule 27B permits taking verdicts on less than all of the charges set forth in separate indictments. Let me read that again. Noting in the context of deadlock, the rule permits taking verdicts on less than all of the charges set forth. Oh, it's just saying you don't have to give one for everything if there's separate indictments. So this one, Commonwealth versus LaFontaine, affirming partial verdicts taken after judge asked jury whether it had reached a verdict on any of the indictments. The inflexible prohibition on judicial inquiry regarding partial verdicts advocated by the Commonwealth would inevitably determine defendants' important and constitutionally protected interest in being able once and for all to conclude their confrontations with society through the verdict of a tribunal they might believe to be favorably disposed to their fate. Like a jury of your peers, basically. And the danger of unfairness to the defendant from multiple prosecutions exists when a trial is aborted before it is completed, as well as when the defendant is actually acquitted. The Commonwealth's proposed rule would also undoubtedly hinder law enforcement interests by precluding courts from asking whether a jury may have reached a guilty verdict on some, but not all, standalone counts. It is uncontroverted that, according to the jury of her peers, following trial, Ms. Reed was unanimously found not guilty on counts 1 and 3. That undisputed fact must not be lost in this analysis. It bears repeating that at the heart of this policy against double jeopardy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potential instrument of oppression. All right, and we're almost done here. Assuming arguendo, I think this is the last one, this court finds that counsel consented to the mistrial. The defendant's personal consent was required. So even though Judge Cannoni is saying because counsel didn't object to a mistrial, then that waived the defendant's consent, but it didn't because they didn't have the opportunity to discuss it with her. So that's what I guess this argument here. So the defense respectfully submits that whether to consent to a mistrial and risk the prospect of retrial should be a decision for the client who must bear the consequences. Some basic trial choices, including the choices to plead guilty, waive a jury, testify in her own behalf, or take an appeal, are so important that an attorney must seek the client's consent in order to waive the right. Commonwealth versus Nolan, holding defendant waived double jeopardy, where after consultation with counsel, the defendant elected to accept the offer of a mistrial. But see Daniels versus Commonwealth. The defendant in Daniels does not appear to have briefed this issue. The Supreme Court has recently shifted the balance of power between counsel and client regarding fundamental decision-making in criminal cases. United States versus Hashimi. Assuming arguendo, the court finds that counsel consented to the mistrial here. The defense contends it should additionally address whether the decision to forego a jury verdict is among the fundamental questions that must be decided by the client, as urged by the defendant in the court below and in this appeal. Notably, the trial judge did ensure that Ms. Reed was personally consulted regarding less weighty matters. For example, on May 24th, the court called Ms. Reed to sidebar and personally asked her to verbally consent to Attorney Jackson's absence on the Tuesday following Memorial Day and that co-counsel Attorney Yannetti could represent her that day. Remember, they had requested the transcript for that when they first appealed to the SJC, and everyone was like, why, what do we want to know from that? It was actually because Judge Cannoni pulled Karen up to her bench and said, is it okay? Or I just want to make sure you know that, it's okay that Alan Jackson is not going to be here and David Yannetti's going to finish the cross on Brian Higgins. Is that okay? And she said, obviously she said, that's fine with me because that's what happened. So, um, she wanted to know Karen's consent on that, but yet when it comes to calling a mistrial altogether, she doesn't need Karen's consent or allow attorneys to consult with Karen either. So, for all these foregoing reasons, Ms. Reed respectfully requests that this honorable court reverse the trial court and orders counts 1 through 3, or 1 and 3, to be dismissed. So they want the counts dismissed. Yeah, so they want the counts dismissed. It doesn't even say to remand it back to Judge Cannoni for an inquiry, which might happen. That's probably what is going to happen. If anything, they will tell Judge Cannoni, this is back in your hands. You need to ask every single juror what their uh, what their verdict was and put it on record or something to that effect. If you want it formalized, then do it formally, bring them all in and ask them the question. It's really not that difficult, and other judges do it all the time. We're seeing it all the time in these other cases, especially as of late with social media and people being able to call people out right away when something may interfere with jury. Like, so in the Ashley Benefield case, which I'm covering, I just started covering the deep dive. I released the first episode last night. So in the Ashley Benefield case, during her trial, there was someone on the law and crime chat talking about my sister's on the jury and this is what they're saying. She's going to be found guilty, blah, blah, blah. Like all this stuff, he knew things that was going on in the jury or in the deliberation room that actually did come to fruition. So this guy, he has inside information, and the jury is not supposed to be speaking to anybody about the case. So obviously, if that is true, that's misconduct on the part of the juror. So they need to bring them in, and that is exactly what the judge in the Ashley Benefield case is doing. He needs to rectify the problem. You can't just let this go. Like, this woman's acquitted on 2 counts, and you can't just let it go. You can't just let it be another stain on the state of Massachusetts. It needs to be rectified. So hopefully the SJC will do the right thing. It would be great if they just came back and said, you know what, we will dismiss all the charges, but I don't think that's going to happen. I think they're going to make Judge Cannoni inquire of all of the deliberating jurors as to what their final verdicts were on counts 1 and 3, because that is ultimately what we need to get to the bottom of. And for some reason, Judge Cannoni is not allowing this, and it just makes me wonder. Just makes you wonder. A lot of things about this case makes you wonder. Why is she so adamant on protecting these uh, jurors and not asking them questions based on, did you acquit? Really not that hard of a question. So I don't know. We know something's fishy is going on in the state of Massachusetts, and this is just one of the many, many fishy things going on. So let me know what you guys think of this appeal. How do you think it's going to go? What do you think is going to happen once they do give their arguments? The Commonwealth is going to have time to give their arguments too. I believe they have an opportunity to file a brief as well because they have to do arguing. So these briefs are so that the justices can go into the arguments fully aware of what's going on and what the situation is. So, having read that, they should be able to understand, oh, okay, I'm fully up to date on what this whole thing is with the whole jurors contacting the attorneys right afterwards and blah, blah, blah. So, that's part of then, they have this background knowledge going in, but then they also need to argue it as well during their hearing to convince the justices to either dismiss the charges altogether, charges 1 and 3, or to do some kind of inquiry with the jurors, which is probably going to happen because that was the original motion from the defense. If you remember, they wanted an inquiry of the jurors or the counts dismissed. So that's ultimately the goal. And we feel strongly that, calling all 12 jurors in is going to give you the same result that she was acquitted. So that's all they need to do. It's not that difficult. Let me know in the comments below what you think, how this case is going. Crazy, crazy times. My next episode I wanted to do on bad cops and their punishments that don't fit the crime. However, that was actually going to be tonight's episode, but this came out, so I wanted to get this to you first. So be on the lookout then for an upcoming episode of Bad Cops. And obviously, Turtle Boy, I never saw a post for his blog, so I will make a new episode on that as well. So I'll see you guys in the next one. Please make sure you are subscribed, and I will talk to you guys later. Bye. Have a good one.